How about if the court limits it? And the reason, here's the example, okay? So anytime you have a witness say, I overheard this person say this, or whatever that statement is, and then you have another person who said, oh, and by the way, they're a liar and they told me that they made that up, okay? How is a witness coming in any different than a post that person disseminates where they say, you know, I told the police one thing, but that's not really how it went down?
Well, the problem is, I mean, Mrs. Triessl, no disrespect, but this is a classic fishing expedition. It's a classic. We don't have any information that there are posts giving contrary evidence. All the defense is saying is, we want to look at everything in this person's life to see what we can come up with. We want to look at everything in Trayvon Martin's past. We want to go through his 5th grade underwear to see what we can come up with. And
Agreed.
you can't do it.
That I agree with.
I mean, look what we've done for rape victims. A rape victim now, you can't, you know, in the old days you could get a psychiatric exam, you could go into prior sexual history. None of that is possible anymore because we want to protect victims. And to say that Trayvon Martin, who gets shot, is somehow that his entire past is, that the defense has open season on it to put it out on ABC? No.
No, I agree with you. I agree with the school records and everything else. Not only is it irrelevant, I think it's inflammatory. I think it takes away. It absolutely does not have anything to do with how he acted on that day. However, if a witness has given a statement, and this is the key material witness for the prosecution, and then in subsequent posts, blogs, texts, she says something contrary, I think the defense should be allowed to explore it and impeach her for it.
Oh, if you have information, if you have somebody who said, you know, on Facebook she said this, went to the police, she said that, you don't have that. You have the defense saying, well, maybe she did.
Ryan, is it your understanding that there's somebody that came forward and said what she's putting out there is... How did this come up?
So the defense attorney, Mark O'Mara, he could not specify details about this. So what he said was, we have internet sources that tend to show that there is evidence contradicting her statements she gave to police. He didn't go in any further detail. He was just trying to show bare relevancy. And that's basically what the judge had to go off of. He explained it, used an analogy where the evidence shows I tell the police I have a migraine, and then, you know, there's evidence on my social media posts that I was at a loud sporting event the next night, like that same night. Things like that. That was the analogy he used to show.
And you cry foul. You say that's definitely not enough. It's not enough.
It's not enough. If he can make an affirmative showing, if he can show something positive, something relatively, if he can show probable cause, a relevant standard of probable cause, something other than, I think there might be something there, that's not good enough.
We want to know what you think on these two issues. The first issue is, are Trayvon Martin's school records relevant and why? And then the other issue, which is really one that's sweeping the country, is how much is social media going to be and should be part of a criminal case? Should George Zimmerman's attorneys have access to Facebook and Twitter pages and emails and texts? Should they be able to use that in the defense of their case? We want to know what you think. Is social media becoming a part of a criminal case, a civil case? Should it be?